morning, everyone. My name is Michelle Jochner, and as the president of Scribes, the American Society of Legal Writers, I welcome you to today's Book Awards CLE program. Scribes is celebrating its 75th year as a national organization of legal writers dedicated to championing excellence in legal writing by promoting clear, succinct, and persuasive style through our publications, awards, outreach, and education. To learn more about Scribes, its upcoming events, and to apply for membership, please visit our website at scribes.org. As a housekeeping measure, please fill out the form that you will find in the chat if you'd like to request CLE credit for today's session. Now, today's program is certain to present a very interesting and engaging conversation with Professor Wes Henriksen, who is an associate professor of law at Barry University School of Law in Florida. Professor Henriksen's book, In Fraud We Trust: How Leaders in Politics, Business, and Media Profit from Lies and How to Stop Them, was honored with Scribes' 2025 Book Award. Congratulations to Professor Henriksen on this very well-deserved recognition. Professor Henriksen will discuss the research and the writing that shaped his award-winning book with the Honorable Michael B. Hyman, Justice of the Appellate Court of Illinois, who is also a very long-time board member and past president of Scribes. Thank you so very much, Justice Hyman, for your career-long dedication to examining and improving legal writing and for being with us today. And if any of our attendees have any questions during this session, please do drop them in the chat, and then we'll take a look at them and we'll pose those questions to Professor Henriksen as we continue. With that, Justice Hyman, you have the floor.
We will begin with, I call you Wes?
Yes, please do call me Wes.
And you can call me Michael. How's that?
Great, thank you.
To summarize your book, all I need to do is read the title and what's under the title. And the title is In Fraud We Trust: How Leaders in Politics, Business, and Media Profit from Lies and How to Stop Them. Explain in further what your thesis is for the book.
So the thesis of this book, as you said, it ties directly into what the title and subtitle say. The thesis started with a question. So I think most scholarly articles or books are going to start with a question that's needling you. And the question that I had was, why are these lies that we are bombarded with nonstop in social media, in the news, in politics, from corporations? Why are these legal where lies on a smaller scale and carried out in a similar way are illegal, and they're called fraud? And so I was trying to figure out the answer to this question, and that's essentially what turned into this book. And so I'd say that's the underlying thesis.
Now, do you realize that we are having this conversation in the month of fraud prevention? This is the official month of fraud prevention. So since it's an official month, what do you tell us? How can we prevent the type of fraud of a massive scale that you talk about? What are your suggestions?
So to prevent the type of fraud on a massive scale that I'm talking about, I think we would need to first understand how it works, why it's happening, and why people get away with it now. And so in order to stop it, it's a multi-level. I'm not going to be able to answer that question fully, I don't think, in one sentence.
Nor do you answer it in the book, because why don't you explain that as well?
Oh, yeah, I think I do answer it in the book.
Well, you don't give any statutes. You allow the process to come up with an answer to that.
Right. So what caught my attention was how fraud, as we understand it. So let's take a step back for just a second and say, well, what is fraud exactly? Well, fraud is where somebody deceives another person intentionally, and through that deceit causes some kind of harm or deprives the victim of something rightfully theirs. And so this is something that's been happening since ancient times. But now in this new modern digital world, the opportunities for gaining from that, for gaining position or money or property through that sort of mechanism, through that wrongful conduct, there's opportunities for that now to carry it out on a mass scale where it didn't happen before. Yet the laws that we have to address it are kind of stuck back in the past. They got solidified in the 1800s when fraud was really a one-on-one type of wrongful activity. So now it's being carried out on a mass scale. How do we stop that? Well, I think we would stop it by number one, recognizing that it's occurring and calling it fraud and saying we should draw the line at fraud and make it illegal, whether it's carried out on a small scale or a large scale. That would kind of be a step one. And step two would be to implement changes in the law that reflect that different understanding that fraud should be prohibited, even if it's carried out on a large scale.
One of the problems with that, as you discuss in the book, is the First Amendment. Why don't you discuss how that plays out in trying to control massive fraud?
So, yeah, I think on one hand, it is a quote unquote problem with that. However, I am a First Amendment scholar and a First Amendment fan. So I think the First Amendment is an absolutely fundamental liberty that we need to make sure is also protected. It's there for a reason. But there's an exception to fraud. I'm sorry, there's an exception to the First Amendment for fraud. Fraud was never intended to, I'm going to back up here. The First Amendment was never intended to protect fraud, and it wasn't understood to protect fraud even back in 1791 when the First Amendment was ratified. The problem is the definition of fraud has been narrowly drawn to reflect how it worked before, but fraud is being carried out now in a way that falls outside the boundaries of this exception to the First Amendment. And I argue that that exception needs to be reimagined, reinterpreted to encompass the types of fraud that are carried out now. I say fraud is fraud no matter what size it is that's being carried out. And so the First Amendment, I think, is a problem only because it's being misinterpreted. But there are several options for actually prohibiting fraud on the public, which is what I call frauds carried out on a mass scale, consistent with the First Amendment, and which would actually still uphold First Amendment jurisprudence as it has been passed down to us from the First Supreme Court, and also uphold First Amendment principles and the reasons that we protect free speech in the first place.
So you break it into politicians, media, and business, corporations. And there's nuances in each of those areas. You discuss them separately. Can you explain to everyone how those are unique and different, but still can be attacked through some laws?
Yes. This is a very difficult subject to abbreviate because it's so deep and there's so much to talk about. But in short, you have three speech categories that are at issue here with fraud on the public: politics, media, and business. On the politics side, political speech has the highest First Amendment protections, as well it should. And this is the area that's most difficult to try and put in regulations that would actually prohibit or punish falsehoods or fraudulent speech. States, time and again, have actually passed laws to try and stop lying in politics. This is something that's actually, it has broad bipartisan support politically, because people do not like the idea of politicians intentionally misleading the voters and intentionally misleading the public in order to try and gain office. Yet at the same time, it's a difficult business to try and, let's say, criminalize or prohibit lying in politics, because the power to determine which politicians are lying and which are not is, of course, itself a powerful political tool. And so any efforts to prohibit false political speech would definitely need to have some sort of insulation from the political process and from the leaders in power. Media speech, which is the second category, it has similar very high First Amendment protections because we don't just have freedom of speech, but freedom of the press has its own standalone right, which is there for a reason, which is we really want the press to be free from political interference, from the government stepping in and telling the press what it can and cannot report. So likewise, we have to be very careful with regulations prohibiting, let's say, fraud on the public by media. And then with social media, you have the issue of whether a social media platform might be expressing views itself or might be simply serving as an intermediary or a platform by which others are spreading their own messages. And so those implicate a bunch of interesting and difficult questions as well. One thing on the media front is there are numerous more speech protective measures that could be put in place to help address the media falsehoods, which would be short of, let's say, outright bans or any punishment. Requirements for links, for example, to truthful information or disclaimers or something along those lines, which would still allow perhaps speech to happen in the media. The third category, I know this is a very long answer and I apologize.
It was a
The third category,
it was a very broad question.
yeah, the third category, which is business or corporations, this goes into commercial speech, which actually poses a lot fewer difficulties or complications when trying to prohibit or punish false commercial speech. Commercial speech has lower protections than political speech or media speech. And in fact, there are no protections for false commercial speech per se. And so we already have laws in place for false and deceptive business practices, false advertising, misleading labeling, and things along those lines. So there are ways and mechanisms, at least when it comes to commercial speech, that in practice, we could stop fraud on the public by corporations. So the reason that hasn't happened is of course a little bit complicated, but in short, there has been numerous instances in the past 50 or 60 years where corporations have knowingly misled the public, caused an enormous amount of harm, and in effect got away with it, even if some of these industries were much later held to some account. None of them actually paid the price for most of the fraud that they carried out.
So one of the things you begin in the book is to talk about human interactions, and that lying, fraud, misrepresentations is part of human nature, and that we begin lying as young as 2 years old, although you say we're not very good liars at 2, but by the time we are 5 or 6, in your case, when you told your mother about the cookie, but we won't talk about your taking the cookie, what you did with the cookie, but
I appreciate that.
That you could lie much better, although you did not do a very good job with your mother. And even mammals, dogs and chimpanzees have been known to misrepresent. And so, the fact that this has been with us so long, and another thing was the Hammurabi Code, 45 some thousand years ago, 4,500 years ago, the first, I think, 3 or 4 paragraphs have to do with fraud. What do we talk about? Human nature and how it's just been with us from the very beginning.
So the reason that I go into lies in such depth at the beginning of the book is because in asking the question, what can be done about fraud on the public, it necessarily implicates prior questions. Like, first of all, what can and do we do about fraud? And then how big of a problem is fraud and how does fraud work? And so in just sort of digging one question after another and figuring out where the source of the real problem is here, it's necessary to understand how lying works in general, because fraud is always based on a misrepresentation of some kind. It is a communication or an action by somebody to mislead somebody else into believing something false to be true. And lying is, of course, woven into human society, and we all tell small lies all the time, little white lies, and that's a normal part of everyday interaction. But you see that these lies, some of them cross a line. It's like some lies are probably lies that we don't want to prohibit or punish. It just wouldn't make any sense to prohibit or publish all lies. That would be far too much an infringement on people's rights, let's say, and a disruption to society. But some lies are just too harmful to allow. And legal codes, going back to the earliest legal codes that we have uncovered archaeologically, so one being the Code of Hammurabi from 4,000 years ago, the first 4 laws in the Code of Hammurabi prohibited certain kinds of falsehoods. The first 3 are actually different types of perjury. So they would say you cannot bear false witness with regards to this kind of crime. And all 3 kinds of perjury were, of course, on pain of death. And so lying was a deadly matter back then. So and then the 4th law was a law against certain kinds of fraud. So that would be defrauding other people with regards to silver or grain. And so those would be 2 of the kinds of ways that people were carrying out frauds back then. So even back then, it was well recognized and codified in law that you can't really tell when someone is lying to you. And so you need to impose enormous consequences on certain kinds of lies, the kinds of lies that we just find are just too harmful to allow. And so perjury, we still have today, and fraud, we still have today. And I thought that that was a very interesting and historically grounded basis for the importance of stopping certain kinds of lies, including fraud.
Let's talk a little bit about your research. And your book has 52 pages of notes, footnotes at the back of the book. And there's 17 pages of selected bibliography. Being selected, that means that's not everything that you may have looked at, but the type is small. So how did you first decide to write this book? Let's start there.
I decided to write this book because I was curious about what, if anything, we could do consistent with the First Amendment about fraud on the public. I don't know that term, if I had that term in my mind when I began, but there's all these less helpful terms that are just kind of floating around in the media, and certainly were 5-6 years ago when I was writing the book. Misinformation, disinformation, fake news, post-truth world, the idea that we're just going to be inundated with falsehoods, and that's just kind of the way it is. And on one hand, there's an argument that might be just the way information works. Maybe that's just the way how communication and information works, and maybe society has always been that way. Perhaps. But on the other hand, there is a strong feeling, and public polling bears this out. There's a strong feeling that there's a problem that's arising, which is all these falsehoods are doing harm to society in some interesting ways, harming the democratic system and faith in democratic institutions, causing harm to health in some cases, causing harm to the environment. And so there's a bunch of harms being caused by these falsehoods that are being disseminated. And I really wanted to know, is there anything that can be done about this? And so just digging into that question is how I began researching the book and what ended up leading to the book.
Did you have a thesis at the beginning of your inquiry, or did it evolve as you worked through the issues?
Well, any thesis that I start out an article or a book with, if I'm going to be doing my work as a scholar, I think, would have to be something that's going to be able to evolve as I go because I want to uncover and discover something along the way. So I think that there's a saying, something like you don't write what you know, you write what you want to know. And that's kind of how I went into this book. It's like, look, I want to know the answer to this. I don't have the answer, which is why I'm going to dig in and research these different questions and try and put this together in a way that illustrates where the problem came from, what the problem is, what it's causing, and how we might be able to go about finding solutions to it. And so I don't remember what my thesis might have been at the beginning, to be perfectly honest, but it probably wasn't what I came out with at the end.
Your sources, your research for this. What was the major areas? I mean, the law review articles, talking to different experts in the field. You're an expert yourself, but how do you do? What was the most important aspect of trying to get a handle on this question?
So there's no single most important aspect. For anyone that's flipped through this book, you will see the earlier parts of the book are more based on social science findings, including deception detection findings, which have nothing directly to do with the law. So, for example, the discovery over the past 6, 7 years, and this is a new discovery, that people really do not have an ability to detect lies, not in any reliable way. Not when they're talking with someone in person, not when they're reading the news, not when they're scrolling their social media feed. They don't have a good deception detection mechanism. In fact, a flip of a coin is about as good as our deception detection. We're at 54%, so we're slightly better than a coin flip. So the earlier part
And
of
you're just for our audience, you're talking about lawyers and judges too.
yes, and that includes people trained in detecting deception. So that,
Police officers
yes, some
who
of
are a
these
little bit
studies
better, you
included
said.
FBI agents, police officers,
Yeah.
parents, trying to detect the lies of their children, spouses trying to detect the lies of their other spouse. And there was this meta-analysis of many hundreds of deception detection studies carried out over 20 years and compiled together by Dr. Tim Levine, and it's a landmark study. It's been cited by thousands, at least thousands of scholars, which is we only have a 54% deception detection rate. Even though we think we can detect deception, we all feel like we kind of know when someone's lying to us. We get a gut feeling, or we go off these cues. But it turns out those are just not reliable. And so the earlier parts of the book are focusing more on social science concepts. And then moving into the later parts of the book, of course, I rely on when it comes to the legal developments, there's the legal developments of the fraud law, which came from common law England and then developed through early American cases. And then there's the Supreme Court jurisprudence on the First Amendment, and then specifically on falsehoods. And that, of course, has to be a cornerstone of anything I'm saying in this book because my thesis does turn on what can or should be done under the U.S. law in order to address this problem. And so understanding where the Supreme Court is now on this, probably the Alvarez v. United States decision in 2012, that has to, if there's one source that has to be the single most important, that might be the one because that shows where the Supreme Court is most recently now on the exact question of can we punish falsehoods under the First Amendment?
Can you just discuss Alvarez a little bit so people who aren't familiar with it?
So the Alvarez case was a case where there was an individual running for a local political position in Southern California, and he expressed many falsehoods or lies during the campaign. But the one that got him in trouble was after he was elected, he at a water board meeting, I don't remember which county it was, but in the Los Angeles area, at a water board meeting, he claimed to have won the Congressional Medal of Honor. And that falsehood ran afoul of the Stolen Valor Act, which was a federal law, which made it a crime to to falsely claim to have won the Congressional Medal of Honor. He was charged and convicted under that. He challenged it on First Amendment grounds, and so it went all the way up to the Supreme Court. And the Supreme Court issued an opinion which struck down the Stolen Valor Act and said that was unconstitutional, because you cannot prohibit or punish falsehoods that are just false and don't cause any other harm or do anything else. It's just a lie. There's no showing that this actually caused anybody any harm. And so that opinion was a very splintered Supreme Court opinion. There was no majority opinion in that case. There was a plurality, a concurrence, and a dissent. And so the justices went all different ways on it. And there were three justices that actually said they would have upheld the act and said there are no free speech protections for intentional false speech. But the court disagreed on which way to go on that. But certainly one of the takeaways from the Alvarez case is, I think, one of the key takeaways when it comes to the issue that I'm talking about in this book, is that the lie that Xavier Alvarez said in that case was one that was punished and prohibited simply because it was a falsehood, like a falsehood about winning the Congressional Medal of Honor. That is really completely distinguishable from fraud in any way, shape, or form, because fraud is always going to involve a couple of other elements. Number one, it's going to be carried out in order to gain some sort of material benefit. And number two, it's going to be depriving somebody of something or causing some kind of harm. And so that case really didn't deal with fraudulent speech at all. And so I think that some of the reliance on it by people is a little bit overstated when it comes to the types of harmful falsehoods that I'm talking about in my book.
If you were to author an opinion in Alvarez, what would you have said?
I don't know that I'm prepared to. I'm a very deliberative type of person, not sort of shooting from the hip, seat of the pants, which is why I'm far more comfortable sitting down and writing a book over the course of a couple of years than just sort of shooting from the hip and guessing what I would say in that case. I'm going to have to take a rain check on that.
You take the fifth.
Yeah, I'll take the fifth.
Yeah. Okay. Did anything in your research surprise you as you were going along?
One thing that surprised me, sort of circling back to something you had made mention of earlier, is just how deep this lying and like telling lies and falling for the lies that others are telling us, just how deeply woven this is into our cognition, our society, and our interactions, and just the way that we humans work. It's not something we think about really all that often. But when I was doing the research on historically how far back, is lying and not just lying, but let's say consciously deceiving other people to get something out of it. This fraudulent type of conduct. How deeply woven is this into us? Well, that was a question that I was looking into, and it surprised me to find that going back through historical stories and documents and holy texts, it's just rife with fraudulent activity going all the way back. And if you just think about it off the top of your head, if you know anything about like old Greek tragedies or the Homer, the Iliad, the Odyssey, going back to the Epic of Gilgamesh, the oldest laws that we have on the books, and then you look into the history of our species that are most closely related to us and look at, well, chimpanzees, do they defraud each other? Turns out they do. there's other great apes. They defraud each other too. And then there's even dogs. We have scientific research on the behavior of canines, which shows that they actually do the same thing as well, which shows this is something just so totally deeply woven into us. And so it makes sense that we would, number one, be very, very good at lying to get something we want. And number two, very, very bad at detecting that other people are lying to us. And so, because of this really odd feature that we have, I think the problem is far deeper than we've recognized to date. And so, that was probably the most surprising thing.
I, I was surprised that you didn't talk about cats. I don't know if cats lie or not, but that should be something that should be looked into.
I didn't go there.
Yeah. But one of the things you did go in to say is that our human default, the public's default today, is to believe what they hear and read. That most people trust the information that they receive and do not seem to consider it skeptically, which as lawyers we're taught to question. But that's not how the public looks at things. Why don't you just touch on that?
Right. And so this isn't my theory, but it's just something that's been well documented and studied in the social sciences and in psychological and psychology literature, which is we have a cognitive trait which is called truth default. And truth default has been well studied. And what it says in essence is we are hardwired to buy into and believe as true, or at least truthful, information that we consume. So, what we read, what people tell us, and we just navigate life through that lens. And it makes perfect sense that we would have a truth default cognitive trait because it's necessary, if you think about it, just for society to work. If we didn't believe most of what we hear and what we see, we would walk around sort of questioning and doubting everything, which you couldn't really operate that way. You need to kind of just take on faith, the stuff you read and the stuff you see. Now, of course, this truth default mechanism, it doesn't apply to everything you hear people say or everything you read. If you don't trust the source, then you're going to automatically not believe it. Or if it's going to be if it's something said by, let's say, a political party you don't agree with, you're going to automatically discount it, or a media source that you don't like, you discount it. But that aside, just with everyday conversations, we default to truth, and this is an important understanding, I think, in order to know how we operate in the world. And it's a necessary thing. And let me just say one more thing on it, which is it's an extremely helpful thing because most people are truthful most of the time, which is why we believe most of what we hear. And the studies have borne out that most people tell very few lies about very inconsequential things. There's a small subset of people, however, and there's a name for them. They're called prolific liars. Um, my joke on this is they should have called them frequent liars, like frequent flyers. Okay. That's my only joke, I promise. But they don't call them frequent liars. They call them prolific liars. And prolific liars, it's a subset of people. It's only about 1% to 2% of people. They tell more lies than everyone else combined. And they don't just lie about little things to lubricate social interactions and to smooth over conversations. They will lie about highly consequential things. And of course, because we're hardwired to buy into most of what people are telling us, we just fall for it. And so this is where kind of fraud comes in. So there's a subset of people that are just highly willing and able to manipulate and deceive to get things that they want. And this sort of exploits, I guess, our truth default mechanism.
Interesting. We have a question. How do other countries that don't have a First Amendment deal with fraud in the public?
That's a great question. I don't have a good answer for that. Because for one thing, fraud on the public's not really one thing. I'm sorry that it's just not that simple. I wish I could say fraud on the public. So there are other systems that have different ways of dealing with, especially over the past 5, 6, 7 years, when there's been this increase in usage of terms like misinformation, disinformation, and fake news and all that. And there are other systems that have, criminalized misinformation or fake news. There's several systems that have, and those types of laws do not work out very well. You can only imagine that the people put in charge of enforcing, let's say, criminal laws that make it a felony to spread misinformation. Okay, so then there have been instances of this in some jurisdictions. It doesn't turn out very good, and it's very bad for people's individual rights because the people enforcing those laws all too often are going to view as misinformation information that they don't like or that they don't agree with. And one unfortunate complication of reality is that with these big issues that are discussed publicly and that are political issues, it's so difficult to get down to the truth sometimes of some of them. And so one open question, which of course some other systems have said, well, we can just make laws against it. I think that any law criminalizing, anything like misinformation, it's got to be very narrowly tailored. It can't be just against misinformation. There needs to be some sort of narrowing principle so that we can get a better definition of what it is that falls afoul of that line. And so I haven't seen a better example in other systems. That's not to say there aren't. There very well might be, but I just haven't had the time to look at all the systems out there.
Well, the one thing we can agree on is Hammurabi with the death penalty. We don't want to go there. That's a little too broad.
Right. Yeah. Yeah.
Let's go on to
yeah.
Let's go on to your writing of the book.
Naming and execution is probably a little too far.
A little too far. So let's go about it. It's a very readable book, and I'm sure that it's not an accident. How did you come about structuring the book and the chapters? How does that develop in your case?
So it developed in two phases. Phase one was coming up with a book proposal, which is going to have an overall structure of the book and a couple of early chapters. And this is kind of the first phase, which is it's very difficult to come up with a book proposal which is going to look like it's going to become a good book. And then if the book proposal gets accepted and it's going to be published by somebody, and then you got to write the full book. The second phase is actually filling it out and writing it. And I can say in both of those phases, there was just a lot of hard work and a lot of changes that went into it. I think in structuring the book, in completing it just like any writing, there's no shortcut, I would say. It's a process. It's a long process. It takes a lot of work, and it takes a lot of self-editing over time, which is to say you've got something down. Let's say you wrote the book. Let's say there's a manuscript. You got to step away from it, get some distance, and come back to it with a critical eye, at which you approach it as if somebody else had written it. So you can criticize it and edit it with that type of critical eye. And the final product that you see now, it had there was so much evolution and editing that went into it, mostly by myself, that it was a very long process and is just the product of an enormous amount of work. I think that.
What chapter was the most difficult to write?
probably at the end, I would say probably chapter one if I was going to choose one, because that's probably the one that changed the most from when I first wrote it to how it ended up. There is an enormous amount of writing that never made it into the final book. So I wrote a lot more than what you see in the book, and sometimes it can be hard to just excise dozens of pages, but sometimes it is just so necessary. And I had a lot of unnecessary things in chapter one, which is the chapter on lies and lying. I had a lot of things in there that in the end, they might have been interesting. I might have liked them, but they did not contribute sufficiently to the thesis and just didn't fit. Just didn't fit. And so that made that difficult. The later chapters tended to be ones where they were edited heavily. Everything in this book was edited heavily multiple times. But again, by me stepping away from it and coming back to it. But those later chapters, for the most part, they didn't wholesale change. Where the early chapters, a couple of them did.
When you wrote the book, what audience did you have in mind?
I was hoping to write a book that straddles the line between academic rigor and scholarly rigor on one hand, yet being readable and understandable to someone who's never gone to law school and has no interest in the law per se, but might be interested in, what's going on in society right now. And so I sort of wanted to try and capture both of those dimensions.
It's interesting because one of the reasons that the committee gave you the award is because we felt you did exactly that, that it was extremely readable for someone who had no legal background. Yet, someone with a legal background would find it just as interesting, if not more so.
Right.
So,
I can say that
congratulations on that.
I have had some non-legal readers tell me that later chapters get a little difficult. And of course, there is discussion of case law and doctrine and First Amendment jurisprudence. And yes, these things you can try and make them as digestive as possible, but at some level, you can't even discuss them unless you actually use some of the right terms and discuss it the right way. So, but yeah, I take that as a great compliment, Mike. I'm very, very pleased to hear that.
It is meant as a compliment, and that's why you're here. You were, for 7 years, a legal writing instructor, teaching law students, and you're now teach First Amendment and constitutional law. But how did your legal writing background and teaching contribute to how the book came together and the language you use?
I learned a lot about writing by teaching writing. It's a cliche, but it's completely true, which is when you teach, you learn more than anybody else in the room. You learn the most when you're teaching, And in teaching legal writing, I spent 7 years. I would have about 50 students per semester, and we would have multiple memos and briefs that they would write and multiple drafts of these things. And I gave individualized feedback on every paper. And so I saw everything. And when you see that many papers and that much writing, you can't help but learn. You learn all the mistakes. Of course, you make all the mistakes yourself too, but you see other people make the mistakes. And there's something, I guess, about editing other people's work and redlining. It's not really editing, but just redlining other people's work that imprints things on you that can't help but influence you. And so I think my writing, not just for this book, but I think that being a legal writing teacher made me a better writer in many ways. And I'm sure I'm leaving out some better part of the answer, but it eludes my mind right now.
Since who are a legal writing instructor, and many of our members are have taught or are teachers of legal writing. Uh, Give us, the lawyers also, and students that are listening and judges, a couple pieces of advice that you think are most important in drafting legal documents.
One thing I think that I gleaned from teaching legal writing, and I love teaching legal writing. I love being an LRW instructor. Um, One thing I learned, which helped me teach students subsequently, is when you see let's say you have a class of 25 students and one or two papers are just outstanding, and you see an outstanding job and you're thinking these are the kinds of papers you don't know if you could have written it that well. And when you talk to these students and ask them about their writing process, it's always the same answer. There is no exception. Every single time when you talk to these students, they just did more drafts than everybody else. It happens every time. There's no secret. Now, not everyone knows this. LRW professors know this, but a lot of law students think, well, some people are just good writers and some people just aren't. And of course, there's truth that there's there are different levels of baseline starting point, absolutely. And some people just have written more than others. But when students turn in a top scoring memo or brief, it is not because they sat down and wrote in one sitting an amazing paper. That just doesn't happen. It's impossible. What they did was when you assign the memo, that night they were already getting to work and writing in either outlining or writing a very, very rough first draft. Because the first draft is terrible. Every first draft. Doesn't matter who the writer is. It doesn't matter how prepared they are or how well they research. First draft's going to be terrible. But the key is to just get that first draft. And this is what I would tell students: get that first draft done and do it earlier than everybody else. You will get a better grade if you start off that way. And then when you go back to it, you'll improve it. And then you step away from it and come back to it and improve it. And the students that would do the top memos in class, and of course, Mike, it works the same way in law practice, obviously. If someone's going to be writing a motion, if they start earlier and have more and go through more drafts, it is inevitable that it is going to be better. And so students do not appreciate just how much they can improve their writing and their grade by starting earlier and going through more drafts. And that's the key.
I think procrastination is a terrible trait for a lawyer. And that's what happens a lot of times.
Yeah, and
So,
I think we all procrastinate, and we all have that, you got to find a way to overcome it, I think.
right, I agree. We have another question about AI today and fraud. Uh, what is your thoughts about what's going on now with that, hallucinations and everything else that's going on with social media? And
Well, with
is that something that can
hallucinations,
be controlled? I mean, there's been suggestions in certain countries, I think, in some states about controlling this. Doctors, you shouldn't use AI. They want to have a law that you can't have AI telling people what to do medically, things like this.
um, I think that we should move forward on the AI front cautiously because it's so quickly evolving. And of course, medical advice might be different than legal advice or motions being filed in court. But Mike, you made an allusion to hallucinations, and I think what you're referring to is people are filing motions in court or briefs with case law that's hallucinated. And so they're using AI, and this has happened numerous times, and I think a couple of judges have even been caught doing this, but where there are hallucinated sources. I think just applying the old rules, first of all, anything you sign your name to, when you submit it to court, you're responsible for it. And if it was hallucinated by AI, so be it. How is that different than, you had an associate help you out and you didn't read it carefully? Well, you should be subject if appropriate to sanctions. I mean, in the legal context, I think you just can't take the responsibility away from whichever lawyer is responsible for that work. In other areas, I think just as a general matter, I'm not, sufficiently fluent in the current state of AI, but I would say we should be cautious. I think it's the promises, the promises that we were told a couple of years ago, how it's just going to be a better writer, a better researcher, a better this. That's just not where it is now. And I don't know if that's where it's going, and it might very well might not be. So we should be cautious with it. And I guess as professors, to the extent that we're educators, also students should probably be aware of how it's integrated into Westlaw or Lexis or what have you. But this is not a substitute for your analysis, your writing. I worry for the future, where we're already entering a world where people are getting less writing training, more reliant on searches and artificial intelligence. And I think that that's not a very fruitful pathway for people who really want to succeed and be effective in the law or anywhere else.
Very good. Uh, One of the things you recently did is publish a book of poems about law school for law students. Has poetry, how has that influenced your writing, if at all? You,
Um,
your interest?
yeah, so I love reading, and I love kind of writing as a way of maybe self-therapy. It's just something that I enjoy doing. And I haven't written poems until recently, but it just sort of caught my fancy. I thought I had some things to say about law school, having lived through law school and now taught at law school for 10 years. I thought there was a lot of topics that could be explored and maybe explained a little bit, and poetry was just my way of having fun doing that.
In the last few minutes, I'm going to call this the George Washington cherry tree. He didn't tell a lie. So I'm just going to rapid fire, ask questions. Just whatever comes into your head. We'll just go through a few of these. I know you're deliberative, but I don't want you to deliberate too long. So the first is favorite fiction book.
Jorge Luis Borges, The Aleph and Other Stories, 1933 to 1969. It's a short story collection by Borges, which is an Argentine short story writer. I have an
Right?
absolute
And he was
fascination with.
blind.
Yeah.
He was blind. I actually met him once when I was in,
You met him. We have to
yes,
talk about that later at some
when
point.
I was an undergraduate student, I went and he spoke at our campus. Yeah.
I'm jealous.
Um, your favorite nonfiction book?
Sapiens by Yuval Noah Harari.
Excellent book. He's a great writer, particularly what's going on today. Uh, your favorite writer, legal or not?
I'm going to have to say Borges. I know it's a boring, it's a repetitive answer, but it's true.
In the Portuguese or in English?
I read mostly in English, so his native language would have been Spanish. I
Okay.
read mostly in English, but I read his interviews and essays in Spanish.
Oh,
And
wow.
yeah,
How about the best writer, or one of the best writers on the Supreme Court in the last 50 years?
that's uh,
They're not listening.
okay. So this is not this is
Did you
a
want to ask a friend or poll the audience?
no, this is so this is an answer about writing and nothing else.
Nothing else.
Okay. Oh, wait, the last 100 years?
No,
Okay.
50. I said 50. I said 50.
Oh, 50.
I'm
Okay.
eliminating
Then I'm
Holmes and
okay.
Cardozo and Brandeis. Okay. We all know that.
Oh,
You can
okay.
take the fifth.
Well, it would have been Holmes, but I'm I'm gonna take the fifth.
Okay. Um, how about the best writing advice you ever received?
Um, that writing is rewriting. I'm gonna give you two pieces of advice. Writing is rewriting, in that anything you see that you like, you're like, oh, that's well written. It was rewritten many, many, many times. And the second thing is when you're editing your work, if somebody, if you get somebody else's eyes on your work and they say, there's something wrong with this sentence, here's what you should do about it. They're right that there's something wrong with the sentence. They're always right. But what they tell you to do to fix it, they might be right, but they're often wrong. The fix has to be done by the writer, but the editor is going, and just about any reader will tell you there's something wrong with a sentence or a paragraph.
How about footnotes, legal drafting? Yes or no?
I'll be controversial here, and I'll say yes, Mike.
Uh-oh. We'll have to talk about this
I know,
afterwards,
I know.
right?
I was just trying to keep it interesting.
Yes, thank you. And last one, what separates good legal writing from memorable legal writing?
Well, I guess bad legal writing could be memorable. Um, I can say what separates good legal writing from bad legal writing, which is a lot of practice and drafts. But what would make it memorable, I think, would be there would have to be a storytelling element, which doesn't go to all legal writing, but legal writing certainly where someone's making an argument, and if they tell a good story, then that's going to make it more memorable.
Well, I want to thank you. Your book is memorable, and you do tell a great story, several stories. One of the things you do in your book is you have stories about cases, stories about psychology, sociology, and all the other aspects of the area. And I found it fascinating. So did our committee. And thank you very much for your time and uh, appreciate it. And hope everybody on this month of looking at preventive fraud that in fraud trust is good for this holiday or this month. Uh, President Jackner, send it back to you.
All right. Well, thank you. Thank you. Thank you to both Professor Henriksen and also to you, Justice Hyman, for such a very interesting and engaging session. And I think I see everybody giving their applause, and I will do it here as well. Thank you so very much for shining a very bright light on this very intriguing topic. And Professor Henriksen for confirming that editing and preparing subsequent drafts is so very, very important, as no first draft is ever the last draft, and that good writing is a great deal of work and also a work of art. Also, thank you to all of our attendees for joining us today. We wish you a wonderful rest of the day and hope to see you again soon. In the meantime, do take care, everyone. And thank you again for a really great and enlightening session. We really appreciate it. Thank you, everybody. Thank you. More